Calling case 240555953, the people of the state of Michigan versus Demario James Wilder. The defendant is charged with count 1, robbery, armed, count 2, unlawful imprisonment, store notice, count 3, home invasion, first degree, habitual offender, second offense notice. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Demario Wilder.
Wilder, state your name.
Demario Wilder.
Argument.
Your Honor, first of all, let me apologize for being absent yesterday. Mr. Wilder was set with a bond of $25,000, 10%. And while we recognize, based off the charges, that is a reasonable bond, that bond is still a unmakeable bond for Mr. Wilder. Mr. Wilder, while he is employed, he is he does not make substantial income. He works as a DoorDash driver and he does handyman work on the side. Your Honor, my client does have a prior record, but it is for a CCW. He does not have anything non-assaultive. My client adamantly denies any involvement in any of these charges, so he does intend to fight this. I do want to point out, once he became aware of these charges, Your Honor, he came to my office and he voluntarily surrendered himself. And that is to say that my client does intend to continue to appear until these charges are dismissed against him. So, Your Honor, we're just asking for a reduction in bond to something makeable.
Madam Prosecutor.
Your Honor, the people are asking for either that bond to stay the same or if it's lowered, for there to be conditions added to the tether. In the interest of full disclosure, I went back over the information yesterday, and I saw in the investigator's report, it said that the complaining witness had told police that he knew 3 of the people for 2 years, which does seem to be the case based on what's in the reports. I would just bring to the court's attention that initially the complaining witness said that he knew 2 of the 4, and then at that point, the police did surveillance and they obtained identification information from males leaving the location, and then they showed the complaining witness those photos. It was at that time that the complaining witness identified Mr. Wilder as one of the 4 men, and said that he had also known him for 2 years. In the identification,
I'm sorry, go ahead.
In the identification for Mr. Wilder, there was the question of what did he do, and it said witnessed the kidnapping and had a gun. So for the purposes of full disclosure, that's what's in the file. The co-defendant, who was arraigned as Christian Carpenter, he had initially had a bond of $25,000 cash as surety, tether, and a curfew. At redetermination, it was lowered to $25,000, 10% cash as surety with tether and a curfew. And that's how Mr. Wilder came to have this bond. It is the same as the other co-defendant. So, Your Honor, as far as the prior, I know that the HAB notice says it's CCW. Odyssey says it's reduced to a misdemeanor, and Otis says that it was actually an improper possession of firearm in and upon a motor vehicle. So I think it ended up getting reduced. I just want to make sure the court knew that. We were asking for either the bond to stay the same or if it's lowered, for there to be a curfew added to that tether.
And yeah, at one last point to Madam Prosecutor's argument, as she said, the complaining witnesses matter, and I haven't went through all the discovery, but from what I've read, the complaining witnesses named 2 people initially. One of those people was not my client. He also said that the other 2 people were masked up. So I don't see where we're getting an identification of my client from him, other than the police saying this is someone that associated, and he said, oh yeah, here.
Court haven't heard the arguments of counsel. Court finds that the 25,000 10% bond is unaffordable. Court is going to reduce the bond to 25,000 personal, with the GPS tether, and house arrest. He can leave the home for medical appointments and court appearances only. Thank you.
Your Honor, my client is employed. Can he work? He cannot work.
You said he's a handyman. What are his hours?
He doesn't have set hours.
I mean, if he had set hours that we would be able to, I can't just have a curfew where he just leaves when he wants to leave. So we're going to do house arrest. We're going to do house arrest temporarily. If he gets something that's more standardized, he can talk to the preceding the next judge. Thank you.
Thank you.
Okay. Good luck, sir.
You're all set, Mr. Wilder. State your name.
Henry David Shepherd.
Carbon case 24055700001. The people of the state of Michigan versus Henry David Shepherd. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder, or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Habitual offender, third offense notice. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
Great, on behalf of Mr. Shepherd, Your Honor is here for bond redetermination.
Okay. What's Mr. Shepherd's bond?
50,000 cash assurity tether house arrest.
Okay. Give me 1 second. Oh, yes. Okay. Argument.
Judge, Mr. Shepherd's 31 years of age. Has some past judges like some narcotics. Is on probation for a drug case. He's on tether for a drug case. Nothing assaulted. He does heating and cooling.
I'm sorry. He's currently on tether.
That is correct, Judge.
Okay, what's he on tether for?
Possession of cocaine.
Okay, continue.
And Judge, he has 4 children. Family man, he takes care of his 4 kids. Doing
Sorry, one last thing, Mr. Is he on a
Yes, sir.
personal bond for that case?
I believe he's on probation for that. Judge. So I guess,
I'm not on
Tether was
tether.
on probation?
He has another controlled substance case pending in 16th Circuit Court where he has a pretrial on the 16th. So I think that's where he has the tether from,
It's out in
perhaps.
Macomb, yeah. Okay.
And is he on a personal bond on that case?
Are you on personal bond on that case?
No, I'm on a $100,000 bond on that.
Cash or personal?
Cash.
I'm assuming it's not cash, Judge, because he's with us. If it was cash, he'd be with them. I don't know.
Did you, okay, okay. When this alleged offense happened, was he on tether?
Yes.
February 8th, this allegedly happened February 8th. So he was out.
Oh, he was out. He was out. Okay. All right. Continue.
Yeah, Judge. So like I said, he does the heating and cooling, has the 4 kids, this is kind of, the complaint witness is a family member, not a complete stranger. Obviously it's 2 sides to every story. Miss Douglas is going to give you one of the sides in a second. That's just one of the sides, but it's always 2 sides, and it's a lot going on here. He's on tether. He can be monitored. So flight risk is not really an issue. It's an issue of safety. And I think that if the court separates and has a no contact provision that says, you got to stay maybe in the house arrest, maybe something we got to do, purposes of this case, I think that would suffice in this particular case. Stay away from family. It's not going down the street randomly, tagging people. This is more of a family member, Judge. And I don't know what happened. They got into it. But I do think that the court can impose a bond a personal bond that would suffice along with the no
Well, it's
contact.
my understanding that if a person is on a personal bond and is charged with another case, the statute states that he can't get another personal bond.
And that's what a dollar bond, dollar bond, Judge, with a
Okay,
UPS tether and a house arrest.
understood. Madam Prosecutor.
Your Honor, we actually think the bond of 50,000 cash as surety with tether house arrest is kind of low given the allegations. Even just on its face without the statute, we believe that a money bond is appropriate. He was on probation since October 26th of 2022 on the date of this offense, which was February 8th of this year. He's on bond in the other case. The tether put him at the location where the victim was found. The victim actually had to have at least 3 surgeries. As of the time of the report, he'd had to have 3 different surgeries. And the victim did identify Mr. Shepard as the person who attacked him. He told police that Mr. Shepard had beat him with a bat, hitting him at least 40 times. And so, as Mr. Reagan said, this isn't strangers. These are people who know each other. So it's not a question of whether he incorrectly ID'd. We would point out the report also indicates that at some point the defendant's wife told police that he had called her and said he did it. Now later, the report indicates there was some jail calls. In the jail call, the defendant's wife told him that she did not snitch and that she was actually going to get a woman to go to the police and claim that somebody else did it, Your Honor. And so we do have a concern, not just for safety of the complaining witness, but we have a concern about the integrity of the investigation, given what allegedly took place in that phone call. So we do think a money bond is appropriate. We do think that given the conversation that allegedly took place based on the investigator's report, that there might be some sort of collusion between Mr. Shepard and his wife to create a false witness. And so, Your Honor, given that the victim did ID the defendant, given that he actually had to have 3 different surgeries, that the tether puts Mr. Shepard at the location, we do think there's a danger here. And so we're asking for that bond to remain the same, not lowered, and for the tether house arrest to remain in place.
Judge, I'm gonna just say briefly, it's hearsay on top of hearsay on top of hearsay. Ms. Douglas heard it from somebody else, they heard it from somebody else, they heard it from somebody else. So I don't know, I haven't heard any tapes, but Judge, obviously this has got to play out, but I do think because it's a family member, and I'm not trying to minimize the allegations, but I'm just saying that, if you separate these 2, he can have his day in court. He can tell his side of the story. If he was attacked, if he was defending himself, I don't know, but he can tell his side. I just think that you don't have to keep him incarcerated to do that, Judge. I think if you separate him with a personal bond, with a house arrest, he's not going to go back, and deal with his cousin or whoever the person is.
Honestly, I don't know what he'll deal with, Mr. Reagan.
What house he'll deal with being in the house?
He's on probation.
But for drugs.
He's on for drugs. He's on a tether for drugs. These are not violent offenses. Looks like he just keeps finding himself around
I was
drugs.
discharged.
Hold on.
I'm sorry.
Don't interrupt.
Okay. He was on probation for cocaine. There is a allegation in Macomb County for more drugs where he was being monitored, and while under being monitored, this case occurred. Whether he's defending himself, whether he was in a nut, well, the tether puts him in the location, so we're not gonna really do all of that. But so with that being said, he was on a personal bond. So I don't know what he's gonna do. I don't know if this is because of drugs. I don't know if he has a temper. We don't know. We weren't there. We haven't heard tapes, and wife, standing by her man and all. So I don't know anything about that. But what I do know is that someone did have to have surgery multiple times. That somebody beat the person, allegedly with a bat in his blood and all that good stuff. So that being said, court finds the $50,000 cash bond is unaffordable. Court finds that an unaffordable bond is appropriate in this matter based on the defendant being a threat to the community and a threat to the complaining witness. Court will reduce the bond from $50,000 to $10,000 cash with house arrest and no contact provision. Thank you.
Your Honor, is it possible to get a no contact provision? And I know it's strange, but with Tanisha Shepard, who's his wife, based on the telephone call?
We don't know about the telephone call. I mean, I think we reading off the papers, Judge. I don't know.
No, I'm not going to separate him from his wife, and his wife really can't be forced to tell. Well, that'll get into a privilege thing at a later time. No, no contact with the complaining witness. 10,000 cash. Thank you. Oh,
You're all set, sir.
you're
You're all
good.
set.
Calling case 24055704001. The people of the state of Michigan versus Reginal Travis. Defendant is charged with counts 1 through 2, criminal sexual conduct, 3rd degree, person 13 through 15. Counts 3, criminal sexual conduct, 4th degree, victim 13 through 15. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P727. Oh, sorry. Jennifer Douglas for the people, P72748.
Breaking on behalf of Mr. Travis. Judge, can I have a 10-second breakout room, Mr. Travis?
Take your time. Take your time.
Question.
Breakout room, please. Argument.
Judge, Mr. Travis is 42 years of age, no prior criminal history, to my knowledge, lives in the city of Detroit, has so his entire life, has ties, has 7 children. He works for Chrysler, has so for the last 6 years. So he has, he has some ties. Now, the allegations, as they read, are very disturbing. That's why I really want to get an understanding of these allegations. So, obviously, Mr. Travis is charged with CSC, 2 counts in a CSC 4. The allegations read disturbing. He tells a little bit different story. He tells that he reached out to people once he found out that this young lady was missing. He actually reached out to the parents. He reached out to the police. He went to Redford Police Station at 4 in the morning. He said they cleared him. He says he had no idea initially about the age, and it's not written accurately as it happened in the report, because the report, it's disturbing. But he said it's not as it reads. That didn't happen the way the report reads. So that's going to all, obviously come out in terms of how the case proceeds. So, but right now we have to think about bond. He turned himself into the precinct once he found out that this warrant was outstanding and it got signed. So he's been cooperative in every facet with the police, with the investigation. So I'm asking the court to, and again, no priors, to reduce the bond because he's working at Chrysler 6 years, has a good job, not just a pop-up job. To reduce it, to allow him to be able to go to work on a tether. And if he is not at work, he's to stay at home and not go out the house. Again, Judge, what really caught me was the age thing, and he says that he had no idea about the age and it didn't happen like that. Right. So that's what he refers to, tells me. So that is, and he was shocked, and when he saw the missing person report, he immediately called in and said, "Hey, that's
Right.
Yeah.
So just to be clear, he thought a grown woman was at a gas station looking for her father, waiting on her father.
See, that wasn't the confirmation initially, Judge. And that's what I'm saying. It was written differently in a report. That wasn't how, it was explained to me. So that's why I say there's always 2 sides, and how somebody tells their story. It's like, oh, I tell my story like this to make it seem, maybe I don't know, Judge, but it tells me that's not how it reads. It didn't happen the way it reads. And he's been cooperative. He called. They didn't have to call him, find him on Facebook or anything. He called, and when he saw that they put the missing person, he was like, "Oh man!" And he starts, that's what he took the initiative. Judge, is what he tells me.
Court having heard the argument of counsel. Court finds that the $200,000 cash bond is an unaffordable bond. Court finds that to have an unaffordable bond, there must be a showing that the defendant is either a danger to the community, a danger to the complaining witness, and or a flight risk. The court does not feel that the defendant is a flight risk based on him going to the police and having contact with everyone. Doesn't even think he's a danger to the victim. Don't think that he'll have sex with her or have her perform fellatio on him again. I don't think that's going to happen. But the question is, while Mr. Travis is going to gas stations or liquor stores or Coney Islands, whether he'll see a young girl again that's in distress or runaway, and will he have sex with her in a car? That's where the what's the word? The concern of the court is. Or maybe at a dollar store, or or a bakery, whether he'll just see a girl out there that's in distress, and then he'll comfort her, and while she's under the age of consent, and so and then try to get her help after the fact. So the court is going to err on the side of caution, and find that the bond as it is set is appropriate, and the bond will continue. Thank you.
Thank you, Your Honor.
Would the court consider 10%?
Not at all. Not at all.
Thank you.
Not at all.
Your Honor, is it possible to add a house arrest condition to the tether? The tether doesn't look like
Already
it has
on.
any conditions. It is?
Already
There's a house arrest on there?
That's what I have, 200 cash, GPS tether, house arrest.
Is that correct, Madam Clerk?
Yes, Your Honor.
Bond continues. Thank you.
Thank you, Your Honor.
Good luck, Mr. Travis. Call the next case, please.
Calling case 230-603-9002. The people of the state of Michigan versus Jerome Andre Jackson Jr. The defendant is charged with count 1, breaking and entering a building with intent, habitual offender, second offense notice. Today is the date and time set for bond redetermination. Defendant is in Third Circuit Court. Appears, please.
Jennifer Douglas for the people, P72748.
Deliberate on behalf of Jerome Jackson, who's at Third Circuit Court. Judge is not present, but Judge, for purposes of this hearing, I would waive Mr. Jackson's presence.
Appearance will be waived.
Thank you, Your Honor.
Argument.
Judge, he's 22. He missed his court date, Judge, with Judge Giles and Capius. This is Capius bond. He says that he didn't have the Zoom information. Now, I would note that he has Miss Silva, who's appointed now, and I'm sure Miss Silva is going to make sure that he makes all his court dates, Your Honor. The charge is B&E of a building. It's not an assaultive charge, but it's a concerning charge. Any charge, Judge, is concerning. I'm asking the court to grant a personal bond. I don't know about the Capius history.
Excuse me.
But I do know he has another matter because he's at Third Circuit. So, Judge, I would just ask for personal with the tether in this particular case. And the tether would ensure that we knew where Mr. Jackson is at all times. So, if he does misplace the Zoom date, we can always know where he is.
Madam Prosecutor.
Your Honor, we are asking for the bond to stay the same. We think actually it's kind of low given all that Mr. Jackson has going on. And I know this is a capias, just so the court knows what all Mr. Jackson has going on. Being at Third Circuit, it's not because he has another matter. It's because he has 3 other matters that he is on height of probation on all 3 matters, Your Honor. And he committed all of those 3 while he was on height of probation out of Macomb. So he was on height of probation out of Macomb. He committed three offenses that he pled to on the same day, was sentenced, but these happened on 3 different days. And then he allegedly has then now gone and done this while on 3 different height of probations. We would also point out that on the Macomb County height of probation, that he violated probation, and so his probation got converted to 150 days in jail, and it was closed but still under HIDA. So he keeps getting HIDA, he keeps picking up cases, and Your Honor, based on all of that, it seems as if Mr. Jackson it's unlikely that he just accidentally didn't show up, Your Honor. The date he didn't show up for was the exam on January 30th, and I don't know that he was supposed to be at an exam via Zoom. I could be wrong, Your Honor. But given all of these things together, we do think that Mr. Jackson will only show up when he feels like showing up to court, and that we would also point out, I left out, while he was on the higher probation out of Macomb County, at some point he was designated an absconder from probation. So he does have some history of not showing up when he's supposed to, and he does have a history of not following court orders, conditions, while he is on probation or on bond. So we are asking for this bond to stay the same and for a tether with house arrest to be added.
That's why you have a tether. So if people don't want to be where they're supposed to be, you can know where they are and force them to be where they need to be. That's what the purpose of the tether is for, monitorization. Incarceration is the very last step, I think, Judge. And when you have a non-assaulted case, I just don't feel that, that's in order for this particular case. You're talking AWIM, GB, and that's a different story. But for B&E, Judge, I think a tether would supply with the house arrest. I'm with Ms. Douglas on that. You need to stay at home for a little bit.
Court, haven't heard the arguments of counsel. Court is going to reduce the capious bond to 30,000 personal with house arrest. Only conditions for leaving are for court appearances and medical appointments only.
Thank you, Your Honor.
Thank you.